And now to the non-anonymous and identified Hoofnagle, please.
Good morning, everyone. I'm delighted to be here today. This is my second trip to Israel. It's a real pleasure to come back and see this beautiful country, but also to be part of this program of so many distinguished experts. So thank you, Michael, for hosting me, and thank you, Alana, for making the event so excellent. I'm going to talk today about the idea that consumer protection law is a huge source for cybersecurity rules and norms. I'm going to talk about some of the advantages of the consumer protection law approach, and I want to end with a kind of provocative statement about it. It's often overlooked by cybersecurity experts, and that is, consumer protection law as a source for cybersecurity rules. So I'm going to talk about it in some detail, and in particular through the lens of the Federal Trade Commission. So to situate my talk, I'm going to talk about the Federal Trade Commission and its shape, and then discuss how it regulates cybersecurity. And if I have time, I'm going to talk a little bit about the Federal Trade Commission in the President Trump era. So the Federal Trade Commission is a century-old federal agency in the United States. It's historically unprecedented. It's basically the beginning of the administrative state in the U.S. And as a result, it was born into controversy. It had elements that looked like a legislative branch, elements that looked like a court, and elements that looked like a prosecutor. It didn't fit well within the American framework of government, and so even people like Learned Hand, I'll move to my next slide here. Even jurists such as Learned Hand asked the question of whether the Federal Trade Commission could possibly be constitutional in the American democracy, since it included these different elements. Other interesting aspects of the Federal Trade Commission is that it was actually started to deal with competition law, not consumer protection. But it almost immediately started to do consumer protection cases. And in fact, the Federal Trade Commission's first case back in 1915 concerned a company that was selling what's known as mercantilized cotton. It's like if you have a t-shirt that's kind of shiny looking, and it kind of looks like silk, but it's actually cotton. The very first case the Federal Trade Commission did concerned those shirts. They were sold as silk, but they weren't really silk. They were really cotton. So it sounds a lot like a consumer protection case rather than a competition law case. But what happened with the Federal Trade Commission is that throughout its history, courts can't make sense of it. They can't make sense of how it has all these different powers. And so courts have tried to cabin it to common law consumer protection norms, which are quite inadequate for a modern economy, as I'll explain. So how to situate the FTC? Well, it was created with a legislative act, so it's a legislative created body, yet it has administrative powers. It can determine the meaning of its statute, and it acts like a common law court. And that much of what the Federal Trade Commission does is bring enforcement actions that identify wrongs, and it interprets its statute through the lens of these wrongs. And this is something Woody Hartzog has pointed out in great detail. And so this is the statute, 1938. And what's relevant here for my talk is this last cause, unfair or deceptive acts or practices affecting commerce is like, that's literally the law of the Federal Trade Commission. And that's literally the law that's been used against the Microsofts, the Googles, the Facebooks, and all these other companies in the world to police them over privacy and security matters. So it's important to know that the Federal Trade Commission has two principal legal theories they often get merged together, but they're very different. One is deception. Professor Hotzog talked about that a great deal. Deception is not a controversial legal theory. Liberals and conservatives alike agree that the marketplace should be honest. The more controversial legal theory is unfairness. Unfairness obviously has a normative implication that goes beyond deception, and it sounds like legislation. When an agency comes along and says, what you are doing is unfair, it sounds as though that agency has just legislated against your business model. And as a result, unfairness has attracted lots of controversy and anger, particularly from the conservative legal establishment. I like Paul Rosenzweig. I think he's one of the more interesting thinkers in cybersecurity. And I noticed back a few years ago, he started making these big statements about the Federal Trade Commission and cybersecurity. And I thought, I'm going to open this up and look at this a little more carefully. But back in 2014, in response to a case known as Wyndham Worldwide, Paul says that the FTC has the only effective aspect of a federal program to compel cybersecurity. And that's a pretty strong statement, right? Something that's worth investigating. And that compellence comes from consumer protection law. So what the FTC does in cyber is it uses its unfairness authority to impose reasonable security standards on companies. And there's a whole bunch of effects that come from this application of law. It makes consent more meaningful. So consent is become more resilient as a result of the FTC. And importantly, the FTC has eroded the tradition of immunity, both for intermediaries and for software producers in important ways. And I'm going to try to convince you of that in just a minute. So what does the FTC want? The FTC thinks that if your company collects personal data, no matter what your privacy policy says or doesn't say, and no matter what the terms of service says, the FTC thinks that you have a responsibility to have reasonable security protection. Now, why reasonable? I don't know. I'm not sure that reasonable makes sense. You think about products liability, the product's safety perspective. Products have to be safe even against misuses of a product. So we could have a much higher standard for security, but for whatever reason, the FTC chose reasonable. And there's all sorts of priorities we've seen in recent years. Obviously, for sensitive data, the FTC thinks the reasonableness bar is higher. And they're also very interested in things like vendor agreements. They know from the security breach world that a lot of security breaches are actually happening at third-party vendors, not at first-party data collectors. So there's been a lot of emphasis on those types of problems. The FTC is a norm entrepreneur. And what that means is it doesn't like to do the same type of case over and over again. What it tends to do is look at things like the OWASP Top 10. And are you all familiar with the OWASP Top 10? These are the major security vulnerabilities that are determined from an empirical analysis of security incidents. So if you have a breach where the root cause is an OWASP Top 10, the FTC might be interested in it. So this raises a really big political problem, and it's a political problem that goes back to the 1910s. Shouldn't we expect the Federal Trade Commission, if it's going to tell companies that they have to have reasonable security, shouldn't we expect the Federal Trade Commission to tell us what reasonable security is? And what we've seen in the United States is this kind of bad conundrum where a company has a security incident. They go out and tell their consumers. So that company is a victim, typically, of a hacking attack or the like. And not only do they suffer in the marketplace from having to tell their consumers, you end up getting investigated by the FTC and by the state attorneys general. And so they typically call you up and say, please explain your security breach to us. and tell us how you've remediated it. So they very much feel like they've been, they're the victim, and they've been blamed for being a victim. This is the company perspective. And so the Federal Trade Commission has sued a whole bunch of companies for having security breaches, and those companies have come back and said, no, wait a minute, you can't sue us because we're the victim of a crime. But number two, you've never told us what reasonable security is. There is no reasonable security, is what they'll argue. And so in some of these cases, defendants have gotten some traction, most notably in LabMD, and D-Link, which is an Internet of Things case, is actually going to be litigated this summer in San Francisco. It'll be very interesting. These are situations where companies are saying, yes, we have consumer data, yes, we had a security problem, but you can't tell me that my security problem actually violated the law. So it's an interesting problem, because when Congress says, okay, well, we'll pass a security law, those same companies come along and say, no, 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 don't pass a security law. So we have this kind of circular problem in the US around this. And as a result, we have a whole bunch of state actors moving ahead. The most consequential in the United States is the New York Department of Financial Services, which passed an in-depth rules surrounding brokerages in New York. And that rule is diffusing across the economy and is applying to more and more companies. And of course, we have the California Consumer Privacy Act, which also creates a private right of action for certain security breaches. So let me jump forward and mention two other important points here. The FTC's consumer protection approach has given more weight to consent. And so we know, especially from Woody's presentation, we often see consent as this long terms of service that we just click on, and that's it. Well, the Federal Trade Commission's interventions have come along and said, no, wait a minute, that's not good enough. We need more visceral consent. We need consent that's much more explicit, and so on. So the Federal Trade Commission's consumer protection approach has done a lot to give more wind in the sails against wiretapping-like activities from devices and the like. And then finally, the other effect of the Federal Trade Commission is actually felt directly in cyber. I mean, one of the things that's not well known is, you remember the bulletproof hosts? The bulletproof hosts? I mean, they used to be in the United States. They're not in the US anymore. They're in countries like China and New Europe. The FTC chased the last bulletproof host out of the United States back in 2009. And it's also brought a whole bunch of other cases against manufacturers and software makers that, in essence, that say that your software is so leaky, it is so problematic from a privacy and security perspective that you're liable for the privacy and security violations that occur, even if you're not the intervening actor, even if you're not the stalker, even if you're not the person who's trying to cause a security breach. So there's been a lot of traction here where the FTC has imposed liability on people writing code, but also on people who are running internet websites and saying, I'm not responsible for what's happening on the site, it's my users. And the great example here is AccuSearch. This is a website that sold phone records, which is illegal in the United States. So what this website would do is, let's say I wanted to stalk my spouse, I could go to this website and they would connect me with a private investigator who would get my spouse's phone records. Well, the website said, we're just in the middle. We're not actually stealing your phone records. The FTC was able to sue them and win, arguing that they were contributing to the security incursion against people's phone records. So I want to sum up real fast so that we have time for Q&A and so on. So let me talk a little bit about the President Trump era. There was a lot of concern about the Federal Trade Commission when President Trump was elected, because some of the people closest to him appeared to be opponents of administrative law. But what's really interesting is that President Trump appointed great, qualified members to the Federal Trade Commission. Each commissioner is qualified and is a reasonable choice. President Trump's nominations to the FTC are actually better than President Obama's and President W. Bush's. Interesting outcome. The other thing we're seeing at the Federal Trade Commission is a call for more cost-benefit analysis. And it's really gotten to a level that's pretty crazy. They just did a regulation on spam, and I wrote a comment that we should require spam opt-outs to be a certain readability level, you know, like black text on white background, so that you can actually read the text. And they rejected my response because I didn't include a cost-benefit analysis of how much it would cost to make the font black. But you know, if HTML authors in the room, yeah, you know, yeah, a couple. So it's not a lot of cost, but there's a lot of focus now on cost-benefit analysis at the Federal Trade Commission. And if you're before the agency, you have to, when talking to the agency now, you have to talk in the terms of cost-benefit analysis. But what I want to conclude with is a kind of basic provocative statement. Consumer protection law sets a ground level for the quality of products and services that can be neutral. It doesn't have to be based on where the product is from. We can apply the same standards to technologies that are developed in Germany, the United States, or even China. And so the provocative thought I'd leave you with is, would we be in the trouble we are in today with ZTE and Huawei if 10 years ago we told them, you can't sell these handsets, not because they're Chinese, but because they lack basic privacy and security protections? Now, one of the reasons why we didn't do that is that Google Android would be in trouble. My friends at Google say Android comes pre-hacked. But if we had said, let's use consumer protection law, let's create a baseline for quality, we might have been able to deal at least with the handsets and so on without triggering these CFIUS and other regulations that are very heavy-handed and appear to be opportunistic against these countries. So with that, I'm out of time, and maybe we could talk about that a little bit more during the Q&A. Thanks so much.